As promised, we about to get to the rest of this because, bro, we got a lot more videos coming today. Let's just go ahead and break it all down. Let's go. So as you can see right here, this is going to be a combination of two of them. You know what I mean? Motions from the dang United States of America. So let's do it this way. Government's unopposed ex parte application for order sealing documents, memorandum of points and authorities, declaration of Daniel H. Winger. Plaintiff, United States of America, by and through its counsel of record and acting United States attorneys for the Central District of California and assisting United States attorneys Ian Yanello, Gregory W. Staples, and Daniel H. Weiner, hereby applies ex parte for an order directing that the government's unredacted motion to impanel an anonymous jury unredacted declaration of Jerron Farmley and Exhibit B to the Farmley Declaration in the above entitled case be kept under seal until further order of the court. This ex parte application is based upon the attached memorandum of points and authorities and declaration of Daniel H. Weiner. And if y'all hear the fan in the back, hey man, listen, it's hot as hell. The AC gonna do what it's gonna do, but hey, you know what I mean? We gotta do what we gotta do around here. Anyways, Plaintiff, United States of America requests that this court seal the government's motion to impanel anonymous jury unredacted declaration of Jerron Farmley and Exhibit B. For the Farmley Declaration in this case, the government has publicly filed redacted versions of its motion to impanel an anonymous jury and declaration of Jerron Farmley to protect sensitive witness information and other sensitive information. The court has inherent supervisory authority to seal documents in appropriately circumstances. See Nixon versus Warmer Communications over its own records and files. Here, for the reasons described in the attached declaration, sealing of these documents is necessary to protect certain criminal history, records, and the identity of witnesses who participated in the government's investigation, who may testify, and or whose safety or whose family safety may be endangered by disclosure of identifying information. You see, when they say this freaking phrase right here, when they say basically they may, that don't mean that people are going to testify. So basically, this right here is the government accordingly requested documents described and attached declaration maintained under seal will further order the court. So yeah, here's the declaration right here. But we finna get into some messiness. Let me tell y'all what exactly just happened now, though. Basically, what you're getting is the Fed saying, hey, let's seal up everybody's name. Let's keep all the stuff off the record because Durk got people that be spinning, shooting things, and everybody, you know what I'm saying, from our jurors to their families is going to be a threat. Now, Durk's lawyer said, we ain't tripping. So that's why they wrote it that way. But the second motion, man, y'all hit that like button so y'all can argue in the comments. I see y'all do your thing on the other dang video. Don't worry, we'll link it to this and we'll get to the other stuff as well. A whole bunch of things we got to get to, but to make a 4-hour video on this crap, I don't think it's fair to y'all, and I think y'all want to break down and take a break from a lot of stuff that's going on. Y'all ready for this? Let's go ahead and get on with the rest of this. Well, let's get to the BS that y'all want. Yeah, this is what y'all really want. Y'all want the government's motion to impanel an anonymous, I keep saying anonymous, I don't know why, but anonymous jury declaration of Jerron Farmley and attached exhibits. And you already know who did all this, who signed it. Let's get down to the freaking table of contents. Table of authorities, memorandum of points and authorities, introduction, legal background, impanelment of an anonymous jury. I don't know why I said it that way, y'all. I don't know. Reasonable safeguards to minimize any prejudice. An anonymous jury is appropriate and necessary to protect the jury's fact-finding function and protect jurors' safety. Defendants' connection to organized criminality and payments for violence, significant risk of interfere with witnesses and the judicial process. Potential that defendants will suffer a lengthy incarceration if convicted. The extensive and continuous national publicity in this case further requires juror anonymity. Reasonable precautions can safeguard defendants' right to a fair trial while still protecting the judicial process in the conclusion, baby. So these are the table of authorities that they're going to bring up, all of these, and we're not going to trip off of none of that stuff. We're going to keep on scrolling down. This case involves a well-funded, organized attempt to kill one of defendant Durk Banks' rival at a busy gas station in Los Angeles in broad daylight. 3 shooters opened fire, including with a machine gun, missing their intended target but killing SR. The government will prove at trial that all 7 co-conspirators were affiliated with defendant Banks' organization, Only the Family. 5 were OTF members and 2 were recruited by defendant Wilson and promised a handsome reward to help kill their target. To ensure a fair trial, prevent improper attempts to influence jurors, and to otherwise protect the judicial process, the government requests that the court order the impanelment of an anonymous jury. All factors the court must consider weigh heavily in favor of juror anonymity in this case. First, the murder in this case was not an isolated act of violence committed by OTF or its members. In recent years, OTF members and associates have committed other brazen murders, assaults, and violent crimes. Second, this court has already emphasized defendant Banks, the leader of OTF, uses his money, influence, and power to endanger individuals whom he perceives as a threat. Docket 202 at 4. Defendant's vast resources coupled with the expensive reach and violent nature of OTF further justify additional safeguards to keep the jury free from intimidation and harassment. Indeed, defendant's supporters have already threatened government officials to free Durk or face retribution. The jury must be protected from similar misconduct. Additionally, from its inception, the murder case has garnered an extreme amount of media attention that will increase as trial approaches. This case is therefore a precise circumstance where heightened measures are needed to secure the jury's safety and safeguard its fact-finding mission from improper influence. The government's proposal narrowly seeks to anonymize certain confidential information from which jurors' identity can be ascertained without compromising the scope of information necessary for fair and fulsome voir dire. Specifically, the government requests that the names, addresses, and specific places of employment not be revealed to public or parties, including counsel, to ensure all parties can meaningfully engage in voir dire, or voir dire. I believe it's voir dire. My bad. The government has agreed to work with the defense to propose a thorough juror questionnaire. Thus, both the government and defendant will have ample information from which to make meaningful decisions and challenges during the voir dire process. Basically, what they're saying is, hey, bruh, Durk is crazy. Durk done got other people whacked. This is what OTF does as a gang. They kill people. They attack witnesses. They do all of these things. Hey, judge, let's keep all this on the hush. We don't even want their lawyers to know this stuff, which I believe is some crap. I believe what they should do, in my opinion, is they should go ahead and let the lawyers sort it all out. Put the lawyers understood that they cannot discuss any of this crap with their with their clients, and then after that, then they can go ahead, because what they're proposing is kind of dumb in my opinion. Not from the standpoint that people can't get hurt and witnesses can't get hurt. It's not that. But the fact that they want to do that, to me, screams that they're going to prejudice the jury, because we don't want somebody in there who does certain things, or y'all can try to exclude from certain things as well. Now, could it have a good thing? As far as like, oh, they're going to put in this person and that person, meaning somebody who could see it through the scope, not of their little, I don't want to say hill that they're on, but you got to remember, they're supposed to be, and you're supposed to be as the accused, tried by a jury of your peers. There's no way that that's technically going to ever happen. The moment somebody doesn't match certain things, like how you grew up, where you grew up, and all that crap, not sorry. It just is what it is. But let's continue on forward. So to make sure it doesn't get boring here, they're going to talk about the Sixth Amendment guaranteeing the right to a fair trial by an impartial jury. Basically, it's going to sound like, hey, man, we want to make sure that the jury is also good, too, because we don't want them to think they had to find him guilty so that he doesn't get hurt or whatever the hell. I mean, that we don't get hurt or whatever. You know what I mean? So impanelment of an anonymous jury. The court may impanel an anonymous jury where the interests of justice are required, blah, blah, blah. And there's some more stuff. These factors, however, are neither exclusive nor dispositive, and the court should consider the totality of circumstances in deciding whether the jury requires protection, which ultimately I believe that they will. They're talking about basically how certain cats move like the Mexican mafia and all this crap, but whatever the hell. When a court orders an anonymous jury, it must take steps to minimize any prejudice resulting from the risks that jurors may infer from the dangerousness of the trial required their anonymity, thereby implicating defendants. And that's kind of what I just told y'all earlier. Like, you don't want to say, hey, bro, we got to make sure we protect these cats because he's going to be this and he's going to be that and all this crap. Like, oh, yeah, if y'all go ahead and find him, y'all need to find him guilty because he's that dangerous that we can't even have a jury that's you know, it is what it is. Defendant's connection to organized criminality and payments for violence. This is where it gets good. Y'all make sure I hit that like button if you can, man. Because they about to introduce some shit that ain't even there. But it is what it is. The first and second factors, defendant's involvement with organized crime and the group's capacity to harm jurors strongly weigh in favor of juror protection and anonymity. As alleged in the second superseding indictment SSI, defendant Banks is the leader of Only the Family, or OTF. While OTF is in part a rap group, several of its members and associates have a history of extreme violence, including murder. For example, in 2004, 6 members of the O Block Street Gang, including OTF associate Marcus Smart, aka Muwop, were convicted of racketeering offenses that included the murder of Chicago rapper Carlton Weekly, aka FBG Duck. Federal murder for hire charges are also currently pending against 2 defendants who were allegedly motivated to kill by OTF-linked payments. So, understand, that may be the 2 individuals that they're talking about that we don't see. These murders and the other, well, actually, I know exactly who it is. It's not that. It's the ones who murdered D-Thing. But it's going to be revealed in a moment, I believe. It has to be. These murders and the other violent crimes committed by defendants and other prominent OTF members, Farmley Declaration 2 through 8, show the compelling need for an anonymous jury in this case due to the strong link between OTF and organized violence. Among other things, defendants' violent criminal history in use of affirming anonymous, and then they see the FBG Duck stuff. Jury also see United States versus Williams, impaneling anonymous jury where defendants committed robbery and murder as members of a violent street gang whose members and associates are suspected of multiple shootings and killings, as well as other violent crimes, including but not limited to murder, robbery, bank robbery, burglary, drug trafficking, and firearms possession. Just a whole bunch of word salad to basically make this look good. Just like the head of a typical street gang, defendant Banks exerts considerable influence over his associates while attempting to insulate, himself from their street-level criminality. A seized audio message between 2 OTF associates demonstrate this hierarchy. Now watch this. In the message, a prominent OTF associate explains that when people call Banks for money, he gives out $500,000, $600,000 to the streets, including funding his co-conspirators, sliders, slang for stolen cars used to commit crimes. Farmley Declaration 9, Example A, attaching audio clip. Also see docket 105, we ain't finna do all that. The associate describes how Banks controls and influences their operations. That Banks want to know people. What the hell? Bank wants to know who is in charge of what first. That's how he wants shit done. He want it done right. He want people to get their sliders and stuff like that for sure. But he want people to know what's going on so it can be real structured. Situation. Blood not no little boy. Blood not no more little boy shit. He further details how defendant Banks' money comes with a price. That his shit is going to get it done right, where people going to get blamed for their own F-ups. The structure explains why defendant Banks warned an OTF associate as the associate purchased flights for the co-conspirators to travel to Southern California to commit the murder at issue in this case. Don't book no flights under no names involved with me. The allegations in this case and evidence collected during the investigation further showed that defendant Banks uses his power and influence over OTF to promote violence against his rivals and others who stand in his way. The SSI alleges that superseding indictment alleges that 6 hitmen, OTF members, and 2 individuals recruited by defendant Wilson flew across the country at the direction of defendant Banks to exact revenge on his rival. After stalking the intended victim for nearly a day, 3 hitmen opened fire at a busy gas station in Los Angeles and killed SR. But SR's death is not an isolated example of defendant Banks directing OTF violence. So what they're making sure to do is that they say, hey, Durk already has a structure to the gang. He already has one. So we're just going to go through and we're going to show you a couple of examples. And that's what they're going to do to try to bury him under the freaking kitchen sink. It's genius, but it also could backfire, because if there's ever going to be a time where you want to prove people are liars, it's a time like this. The conversation that was had, right? They say it's directed to Durk or directed by Durk, but they don't have any proof except for words and possibly text messages that we ain't seen just yet. It's still all under seal. So let's keep on rolling. So, yeah. Anyways, The superseding indictment alleges that 6 hitmen, OTF members, and 2 individuals recruited by defendant Wilson flew across the country at the direction of defendant Banks to exact revenge on his rival after stalking the intended victim for nearly a day. 3 hitmen opened fire at a busy gas station in Los Angeles and killed SR. But SR's death is not the only isolated example of defendant Banks directing OTF violence. So, explaining Mexican mafia structures, blah, 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 and all this other crap, including that the gang number of associates aspired to become members and were willing to commit crimes on the Mexican mafia behalf, that they also enemies. Oh, here we go. He is alleged to have placed additional bounties on individuals that he and other OTF members wanted to kill. So Banks embraced his penchant for bounties in his music. Rapping, for example, I don't want no niggas who you catch, I want the one I paid for. Trolling ass, we shot your homie. Gucci Mane rumors. Yeah, okay. And yet another federal murder for hire case in Chicago involving the death of SM. Banks was alleged to have offered money for people to kill those responsible for his brother's murder, and more specifically offering to pay money for any gangster disciple that is killed. Indeed, just 2 weeks following the murder of SM, the suspected leader of a faction of gangster disciples, the alleged shooters discussed payment from OTF and defendant Banks. Alleged shooter texted another alleged shooter, "What's up with OTF? What you mean they not paying? Did Durk give you that money?" Moreover, and that's not even what happened, bruh. He just went up there to go kiss ass and link up with Durk, and then he asked him where the money came from and asked if Durk gave him that money. So, come on, man. Moreover, defendant Banks has threatened to unleash his OTF associates to stalk and hunt his rivals. For example, in a seized text message thread between defendant Banks and other OTF associates, including defendant Wilson, ooh-wee. Banks boasts about threatening a rival, telling him, "I got him hunting you up, ads. Better have 3 ski masks on." Docket 105, EX2 under seal at 12, emphasis added. And in a similar thread, defendant Banks and his OTF associates discussed defendant Banks' heated exchange with another rival, with defendant Banks telling his associates, "I'm finna pipe it up." A common street reference to a use of a firearm in response to an OTF associate agreed to follow defendant Banks' lead, exclaiming, "Blood is green" emoji of a car and traffic light. Getting shit together now. No phones referring to green light to act on defendant Banks' wishes for violence. The above describes structure of the criminal side of OTF. See, this the problem with that one too. If somebody called me and threatened me or say whatever, nigga, I'm about to get guns too. Y'all not about to sit up here and bully me. Although Scoom his ass does not appear to have been officially released by a defendant, the lyrics are authentic as government seized audio file from a co-conspirator's cellular phone pursuant to a federal search warrant. So they got that from a fake song? Man, come on. Defendant Banks funding and considerable wealth, the power and control he exerts over his associates with desire to seek revenge on those who cross him, and his associates' willingness to do what they are told, all show the need for an anonymous jury in this case. Significant risk of interference with witnesses and the judicial process. Defendant Banks has repeatedly shown a disdain for the judicial process and witness who may cooperate with the defendant. It is therefore not surprising that witness interference has already occurred and is likely to continue in this case. Such interference weighs strongly in favor of jury anonymity. United States versus Boyajian, where defendant in a prior case persuaded minor victim not to testify and threatened victim's family member. Banks has made clear his contempt for cooperating witnesses on a popular podcast that currently has over 1 million views. Banks exclaimed, "I hate all rats," he elaborated. If you ever tell, I hate you, like with a passion. That made me who I am today. That took away half of my life. Mother effer telling on my pops. So I really hate rats with a real passion. Like I said, I hate you. Bad. I'm looking to the camera. I hate effing rats. Yeah, but y'all failed to mention what he just said. He hates snitches because they took his dad away from him. Why would you like snitches? Come on, bruh. Giving Banks vocal scorn for those who may cooperate with the judicial process, it is predictable that suspected witnesses in this case have already been subject to threats and intimidation. See DJ Academics' Lil Durk's realest interview ever, last interview on Off the Record with Academics, available on YouTube. Explaining that members of the Mexican Mafia Code, we don't really care about that. Testifying court document. One of the group's defendants murdered or attempted murder, we don't care. To start, one of Banks' trusted OTF associates has already threatened a suspected government witness. Specifically, the OTF associate told the witness family member that the suspected witness was a snitch, a snake, and was not for the family. An undoubted reference to Banks, only the family. Such threats to witnesses, even when committed by a defendant's associate, are precisely the type of conduct that justify enhanced juror safety and procedures to ensure the jury can fulfill its duties with out improper outside influence, upholding use of anonymous jury when defendant was the leader of a motorcycle gang with history of violence and witnesses, saying where defendants sought to bribe and threaten witnesses, had attempted influence, prior state case. The witness intimidation in this case is not limited to clandestine communications. The public speculation about potential witnesses has already had significant consequences. Such public mention of reprisal against suspected witnesses shows the reasonable interference that a juror may fear that their identities could be disclosed online, exposing them to threats from individuals who are directly associated with defendant. United States versus whoever the hell they got right there. And let's see. Defendant Banks has also shown a repeated disrespect and willingness to impede the judicial process, despite admonishments from 2 courts about phone violations at Los Angeles MDC. Defendant Banks has escalated his defiance of BOP rules that keep witnesses and others safe. In late August 2025, BOP officials seized an Apple Watch with cellular capability from defendant. Even more troubling is Banks' conduct after he was caught. Rather than accept responsibility for this violation, defendant allegedly obstructed the investigation, attempting to damage or destroy the communications device. Is they're piling it on. They're basically saying, oh, there's lyrics, there's this, there's that, unreleased songs and stuff that he was talking about and all of this crap. And that's why they're going to try so hard to get the lyrics thrown out. It's ultimately not going to work, because what they're going to attempt to do is say, these lyrics are part of his lifestyle. Look at this, look at this, look at this. We already heard from from Illinois, that Lil Durk is not freaking being sought after in the quote-unquote murder for hire in Chicago, because the 2 dudes, even though it's still under seal, so it could come back to bite him like a snake. Let me save myself for that one. But basically, they already said, we're not looking at Durk for any of this crap. The story of Buddy getting greased in front of the community center and the dudes who did it, bruh, they were bragging about it. They were trying to say, hey, this actually is the dude who did this. And on top of that, I know that myself, I would have to say, bro, you think somebody ain't going to feel some type of way? And you don't think that Durk ain't going to try to portray himself as a big old boss in his freaking music? So to say he put $500,000 to $600,000 out in the streets, to whom? Gotta ask that question. In the DJ Academics interview, I put it up on my Instagram, but that's what he get when he brought me on this goddamn thing and he was talking shit. Oh, what did you say about this right here? They're saying this in the chat. Yeah, the chat, chat my ass. But nah, in all candor, bro, this ain't as bad as y'all making it. Him having an Apple Watch that can talk to people and all that crap, who doesn't? And on top of that, don't you think if he was such a violent person and all this crap, granted he hasn't seen anything, he has an idea and people talk. If that was the case, certain people would already got smacked out the way. What's happening is people are speculating and saying certain things. But where are the arrests from people who are intimidating these witnesses and all this crap? When they say, oh, well, these people were threatened and these people were threatened and all this crap, y'all have the resources to track and trace phone calls. So I'm just wondering, if these people were such a threat, why are they not in jail? Y'all were able to go find every single person who rushed up the Capitol building in January 6th. So I'm just curious, how the hell y'all can't do it for singular individuals who are threatening lawyers, threatening judges? To me, come on, bruh. Y'all pushing the envelope on some straight up bullshit. But let's go. Let's keep going. Rather than accept responsibility for this violation, defendant allegedly obstructed the investigation, attempted to damage and or destroy communication device. Explaining that defendant's disrespect, if not outright contempt for the process by which the charges against them will be resolved, surely strengthens the case for impaneling an anonymous jury where defendant refused to permit officials to execute DNA warrant and engage in appropriate courtroom. That's Asian off, whatever the hell. Defendant's interference with judicial process, including destroying his cell phone to prevent recovery of evidence, weigh in favor of anonymous jury. So why didn't Durk Banks freaking destroy his phone when y'all grabbed his phone at the damn Chicago show? That doesn't make any sense. Defendant Banks' flouting of the rules is all the more concerning here. Given the previous judicial admonishments and the nature of his latest offense, possession and destruction of a device that could be used to have unmonitored communication with witnesses or those who may intimidate witnesses or take steps to alter their testimony. Indeed, although the government continues to investigate banks' possession and use of the communications device, initial data associated with the serial number of the watch shows the device was purchased May 26, 2025 and was activated the next day. So you know one of those guards gave that to him, right? It ain't like they freaking put a damn drone and dropped it specifically to him. Potential that defendant will suffer a lengthy incarceration if convicted, as all defendants face a mandatory life sentence should they be convicted of 18 U.S.C. 1958. The potential that defendants will suffer a lengthy incarceration if convicted clearly weighs in favor of an anonymous jury. Potential mandatory life sentence surely provided a strong inducement to resort to extreme measures in any effort to influence the outcome of the trial. The extensive and continuous national publicity in this case further requires juror anonymity. Finally, the likelihood of extensive publicity and the risk that jurors' names will become public is substantial here. Indeed, in Chirac, the mere possibility of media attention was sufficient for the Ninth Circuit to find that this factor was met. This case has attracted significant media attention. Since defendants were arrested, the coverage will unquestionably increase as the trial date approaches. National news has extensively covered each step of the case, including defendants' arrests, defendant banks, detention hearings, even routine and mundane filings like the latest stipulation to continue the trial. The case has also received substantial attention on social media, including in-depth analysis of the case by legal channels. Defendant banks has also chosen to further publicize this case by having defense counsel participate in interviews, so they talking shit about Drew, by using defendant bank's social media account with over 15 million followers to falsely claim the government is using this murder case to criminalize the defendant for his creativity and art. Such extensive coverage, understandably underscored by defendant's notoriety and the premeditated murder at issue in this case, heavily weighs in favor of additional judicial safeguards to protect the jury and preserve the integrity of the trial. Anonymous jury, we're finna get through all that. The risk that defendant affiliates and or supporters will attempt to improperly influence or intimidate the jury are not speculative. To date, defendants' supporters have already attempted to intimidate individuals connected to this case. For example, a United States magistrate judge received multiple voicemails from an individual stating, among other things, that defendant Banks and Wilson were innocent, that if they get life, I'm going to burn this motherfucker down. Burn it to the ground. It's not a gang, bitch. Another supporter issued a similar threat to a prosecutor stating, free Durk or be shot. The extensive and continuous publicity coupled with the threats and the other attempts to impact witnesses' testimony discussed above demonstrate the need for juror anonymity to ensure jurors' safety and preserve their ability to discharge their constitutional duties without fear of reprisal. Reasonable precautions can safeguard defendants' rights to a fair trial while still protecting the judicial process. Because juror anonymity is warranted here, the government requests that the court implement well-established safeguards to ensure that the fundamental rights of defendants are not violated. This court can minimize any risk of prejudice by downplaying juror anonymity and not instructing the juror on reasons for their anonymity, but simply inform them that they would be referred to by number rather than name. Additionally, the government has agreed to collaborate with the defense to craft a thorough juror questionnaire, which will ensure the parties can meaningfully conduct effective voir dire. As explained in McHale, a district court sufficiently safeguards the defense. And this is the last page, counsel ability to conduct voir dire, providing defendants with questionnaire, each potential juror detailing age, material, status, city, resident, employment history, all this other crap, whatever. Accordingly, by way of jury questionnaire and oral questioning, both in Massey, individually, this court can ensure that the defendants have sufficient information to enable them to make challenges for cause and to intelligently use their preemptory challenges. Conclusion, for foregoing reasons, government respectfully requests that this court panel an anonymous jury to protect the prospective jurors and prevent any interference with judicial process. Specifically, the government requests that the names, addresses, and specific places of employment not be revealed to either party. Yeah, we're going to leave it right there. Yeah, the feds deciding to play a dirty, dirty game. It is what it is. But the fact that the defense is saying, all right, let's do it, it's going to be approved, bro. There's no way in hell that this is not going to be approved. But I find it interesting that they're trying to basically paint him as this. And what they're doing is kind of genius by the by the defendants is, y'all plan to use all of this other stuff to even be allowed to come into the freaking courtroom. And that's the thing that's the most bothersome shit, because you're bringing up stuff and they have actual documents stating, bro, we're not going to pursue Lil Durk. We're talking about the case with dude that got killed in Chicago. Then once again, as I stated in the previous clip, y'all have the resources to prosecute these individuals. So how do we know that y'all even taking y'all damn job seriously? So y'all can call in all type of fans and all this crap and everything, but we seen in the YSL trial, right, where Lil Buddy got on the internet and was talking crap about Labatt, Fonnie Willis, and Glanville, and they went and arrested his ass. Sat him down for a couple of years. So I don't want to hear that BS, bro. End of the day, man, this is all about propaganda. And what they're trying to do is make sure that the jurors hear this crap and prejudice them anyways. If you don't think that the freaking FBI and the DEA and all of these craps and all this shit, and you don't think the feds ain't playing a dirty game here, bro, I hate to tell it to y'all. Yes, the hell they are. By putting this stuff out, they know that they're going to get individuals who are going to side with the feds. It just is what it is. But me, I'm going to always question the feds, because at the end of the day, you have to look at it like this. Why are they stating it that way? Why are they throwing all this stuff? Then y'all said basically, hey, technically, the defense don't even object to this shit. So why further with the bullshit? Questions that I just kind of don't want answers to, I guess. But y'all make sure y'all hit that subscribe button, hit that like button, win one of these for free by throwing in your comments right now if you made it this far, man. If you just want stuff just to play out and you want to catch all the new videos, click right here. Other than that, catch up with the very latest last Durk video that we did that's gaining some attention, because some of these bloggers ain't even reading the whole thing. They capture headlines. So click right here and find out exactly why Durk ass might be coming home, because one of the bosses ain't supposed to be a boss. His days were numbered. It's something that Trump ass did. Click right here and I'll catch you on the next one.